Thank you for joining us today. As a reminder, today's session is for information and educational purposes only, and none of the session or the content derived should be interpreted as legal advice. On behalf of the Caribbean Regional Compliance Association, we would like to welcome you to today's event. We have with us two brilliant women here to guide us through the current storm of sanctions. They'll give us some practical tips and misconceptions to avoid. Sara is a partner in the Cayman Islands office of Mourant and is part of the Specialist Global Financial Services and Regulatory team, focusing on regulatory developments impacting Cayman and BVI fund financing corporate structures. Sara has significant experience with both Cayman Islands and British Virgin Islands regulatory matters. And Sandra is the head of compliance and reporting services for Mourant Governance Services in the Cayman Islands, where she provides anti-money laundering reporting and compliance officer services, as well as automatic exchange of information and economic substance reporting services to Cayman Islands entities. Sandra is also an attorney at law and is well versed in BVI and Bermuda legislation. Throughout today's session, you can submit your questions through using the questions panel on your screen, and we'll take them at the end of today's discussion. We have folks joining us from jurisdictions all throughout the Caribbean, so welcome to everyone. Ladies, let's begin your presentation. You are live on the broadcast.
Thanks, Melissa. If we could just scoot through to the introduction slide, that would be great. Thank you. Okay. Well, Melissa stole my thunder a little bit, but on the introduction slide, you'll see that the first point of discussion is to tell you who we are. My name is Sara Galletly. I'm a partner in the offshore law firm Mourant Governance. I'm based in our Cayman Islands office, and I specialise in BVI and Cayman Islands regulatory law. And I'm joined today by my colleague, Sandra Edun-Watler. And Sandra has been a long-standing member of the Caribbean compliance community, as well as being the Cayman Islands representative of the CRCA, the Caribbean Regional Compliance Association. Sandra is also currently the president of the Cayman Islands Compliance Association, or CRCA. And Sandra, as Melissa said, works as the head of the compliance and reporting service lines at Mourant Governance Services in Cayman. Sandra used to work within the regulator in Cayman, the Cayman Islands Monetary Authority, maybe forgot that then, and has also been involved in the CFATF evaluation of the BVI. So as Melissa said, Sandra has a very good working knowledge of both BVI and Bermuda, AML and CFT regimes. So that being said, what's the purpose of this talk today? Well, we're hoping to provide you with a snapshot of the current sanctions regimes applicable in the Caribbean. And though, of course, our focus will be, or we'll be using lots of examples based on the Cayman Islands and the BVI. Sanctions have been the subject of increasing scrutiny by regulators throughout the Caribbean basin, particularly in the Cayman Islands this year. And we've just gone through our CFATF evaluation. So we can provide you with feedback on the assessor's comments and responses, because even though their feedback was given in relation to Cayman, their comments and expectations have very general application, and so will be applicable to other countries and territories throughout the Caribbean basin. Sorry, Melissa, if we can skip backwards to the contents page, you'll see that the format of the talk is, first of all, to go back to basics. And we're going to look at what sanctions are, how they operate, and what they achieve, or at least are intended to achieve. We're going to look at the various regimes which are applicable or relevant to us, including the UN or United Nations, the EU, the European Union, the UK, which may be applicable, and also US regimes, sanctions regimes. And then we're going to look at how those regimes are or can be navigated in practice. Now, I'm going to talk about the more legalistic aspects of the presentation, and Sandra is going to talk about the more practical application, how to navigate that sea of financial sanctions, due to her vast practical experience. I'm talking you up. So we aim to speak for about 45 minutes and leave quite a lot of time for questions at the end. As Melissa said, if you've got a question during the body of the talk or at the end of the talk, please do use the question function to raise that question, and Melissa will collate those and feed those through to us. So if we could move on to Sanctions 101, back to basics. And you can see that this slide poses a few questions which are key to understanding the purpose behind financial sanctions regimes. The first question, and we're really taking a step back here, is what are sanctions? And you can see that sanctions are a political tool. They're a foreign policy tool used as part of broader political and diplomatic strategy, but with the overarching aim of maintaining international peace and security. Sanctions are normally agreed and coordinated at an international level by the United Nations Security Council and by the European Union Commission, and they're applied with respect to individuals, entities, organisations, corporates, territories, countries, regions, and even specific vessels. The individuals and entities which are subject to financial sanctions or sanctions are generally referred to as designated persons. So if you hear that throughout the talk, that's what we mean. Now, because of the purpose and nature of sanctions, sanctions are increasingly becoming the key part of a country or territory's regime to counter money laundering, and in particular, terrorist financing and proliferation financing. In practice, sanctions are not just financial sanctions. Sanctions include travel restrictions, arms, financial, trade, immigration restrictions against those designated persons, entities, or organisations. So financial sanctions are restrictions which are put in place to limit the provision of financial services to designated persons, or to restrict the access of designated persons to funds, financial markets, and economic resources. So we've looked at sanctions, financial sanctions. We're then going to take it even more narrow. What are targeted financial sanctions? Targeted financial sanctions, or TFS, are a specific type of financial sanctions with a stated objective, such as the prevention of the proliferation of chemical weapons, for example. And in practice, if you have a targeted financial sanction against a person, it will mean that there are asset freezing powers and restrictions on using or dealing with property of designated persons. A good example of a TFS, or targeted financial sanctions regime, is the global human rights sanction regime, which was very recently implemented by the UK in July 2020. And this was extended to various overseas territories, including the BVI and Cayman. Now, this won't, for example, have been applicable to those sovereign nations within the Caribbean basin for whom the UK legislation has no impact. We'll talk about that, how that works later on. But going back to the global human rights sanctions regime, the stated aim of that regime is to deter and to provide accountability for actions amounting to serious violations of an individual's right to life, the right not to be subjected to torture or cruel, inhuman, or degrading punishment, and the right to be free from slavery or to be held in servitude, which is a very noble goal. So if we could just pop over to the next slide. The next question is, okay, well, we know what financial sanctions are now. They're a subset of sanctions. What are the purposes of financial sanctions? And I've mentioned that the overarching aim of all sanctions regimes is to maintain international peace and security. But with financial sanctions, we can see the reasons that financial sanctions are implemented are to coerce, constrain, to signal disapproval, and to protect misappropriated assets. So going through each of these in turn, we want to coerce a regime or individuals within a regime into changing their behaviour, excuse me, by, for example, increasing the costs that are applicable, or by erecting barriers to them so that they can't do what they want to do without changing that behaviour. We want to constrain a target by denying them access to key resources and services which they need to continue that behaviour which the world does not want them to continue doing. Financial sanctions also signal disapproval, and here the aim is often potentially stigmatising and isolating a regime or key individuals, or it could be used as a way of sending a broader political message by a large country, and then people who want to be aligned with that country will step in line with their sanctions measures. So those are the purposes behind financial sanctions. The next key question is, who do they apply to? Who has to comply with sanctions? So looking first at the EU, and as a note, I would just say financial sanctions apply a lot more broadly than the designated persons they actually list. And you'll see EU financial sanctions, including those which implement United Nations or UN sanctions, apply within the territory of the EU, which we know is a very large area, but they also apply to all EU persons wherever they are in the world. The UK sanctions regime is very similar. UK financial sanctions apply throughout the territory of the UK and to all UK persons, including corporates, wherever they are in the UK. The UK regime is interesting because it is extended by way of Overseas Territories Orders in Council to territories like British Overseas Territories, including the BVI and Cayman. So that UK regime also has extraterritorial effect. So persons within those territories will also be subject to the UK legislation. In the Cayman Islands, for example, all individuals and legal entities who are within or who undertake activities within Cayman must comply with the financial sanctions regimes which are currently in force. And for those Caribbean countries which are sovereign states, their domestic legislation will of course dictate to whom the sanctions apply, but we can very much expect that those sanctions measures will apply to all the nationals of that territory or state, whether they are in that territory or whether they are elsewhere in the world. So you can see they have very far-reaching impact. What then are the consequences of non-compliance? Well, generally speaking, and this is a broad brush approach based on the UK regime, a person in breach of an obligation under a relevant sanctions measure will be guilty of an offence and liable to a maximum of 7 years imprisonment or a fine, or to both a fine and imprisonment. So not something that we want to fall foul of. And if we could just move to the next slide. So now that we've looked at what sanctions are, we're going to turn to look at how sanctions are imposed. That is, what regimes are in force and applicable to territories throughout the Caribbean basin. And firstly, we're going to look at the two key international regimes, the sanctions measures adopted by the UN Security Council, which I'm just going to call UN sanctions, and those of the EU, which are adopted by the EU Commission, but again, I'm just going to call them the EU sanctions. So looking first at the UN, what is the remit of the UN Security Council? Well, the UN Charter states that the Security Council shall determine the existence of any threat to the peace, any breach of the peace, or act of aggression. And remember that this is on an international level. The Security Council may identify country-specific situations, such as internal conflicts within a regime, as well as potential or generic threats to the international peace and security, such as terrorist acts, or the proliferation of nuclear or chemical weapons, or the illicit trafficking of weapons. The UN Charter then goes on to give the Security Council the power to impose measures. Importantly, those measures must be measures not involving the use of armed forces to constrain those threats to international peace and security. And those measures which can be imposed by the UN Security Council include financial sanctions. UN sanctions are derived from resolutions of the UN Security Council, but those resolutions then require the nation states to actually implement them. They have to adopt local legislation to enforce and comply and introduce the sanctions which the UN Security Council has resolved upon. Now, it's the responsibility of those individual states to comply with the UN Security Council resolutions. They don't directly bind nations, individuals, or companies. And this will, of course, include those sovereign states within the Caribbean. The UN, as I've said, has limited power to compel states to comply with sanctions measures. And so in practice, we can see a difference between the sanctions measures enforced in different territories to reflect the same UN Security Council resolution. Some states may not adopt a resolution, they may not fully adopt a resolution, and some may actually extend the resolution adopted by the UN Security Council and actually impose further sanctions measures. So that, in effect, is a nutshell overview of UN sanctions. Moving on to EU sanctions. The EU applies sanctions to implement UN Security Council resolutions. So as I've said, UN Security Council resolutions don't have direct effect. The EU is clearly a legislative body for its individual member states. And so the EU then passes legislation to implement the UN Security Council resolutions. But the EU also will adopt its own sanctions regimes. For example, the EU sanctions against Iran go further than the UN sanctions, and the EU also implemented and adopted sanctions in relation to Russia in response to the developments in the Ukraine. We can see as well that the EU can adopt its own sanctions as well as extend those which have been adopted by the UN Security Council resolution. And it's interesting to note that although some territories may have the EU legislation and sanctions measures applied to them by the UK, which is in the process of not becoming a member state of the EU, other territories will adopt domestic legislation reflecting EU sanctions where they have strong ties with the EU, or whether that is just a policy of their government. And an example there is Curacao, which we understand adopts sanctions legislation implementing EU sanctions, even though Curacao is not a member state of the EU. Now, how does the EU impose sanctions? Well, some EU sanctions, such as travel bans and arms embargoes, will be implemented individually by the EU member states. So the EU will adopt a directive, and the individual member states have to adopt their own domestic legislation, bringing that into their national law. Other EU sanctions may be implemented by EU regulations, and the regulations then have direct effect in the individual member states. And so no national legislation is required to adopt those, although in practice, domestic legislation is usually passed to supplement EU regulations in the area of enforcement and penalties. So if we could just turn to the next slide, please. We've looked at the international regimes, the UN and the EU. What we're going to look at next is the UK sanction regimes, because this has an important effect. It affects many territories throughout the Caribbean, not the least of which the BVI and the Cayman Islands. Now, the UK generally adopts legislation relating and reflecting the UN and the EU sanctions measures. However, along with many of the nation states, the sovereign states within the Caribbean, the UK Parliament may implement its own sanctions regimes autonomously. And by way of example, in 2011, the UK implemented financial restrictions against Iran, which went further than EU sanctions by prohibiting UK financial institutions from dealing with Iranian banks except under license. And it's interesting that the EU sanctions measures were subsequently brought in line with the steeper UK measures. The UK passed the Sanctions and Anti-Money Laundering Act in 2018, which is often referred to as SAMLA or the Sanctions Act. And that piece of legislation provides the legal basis for the UK to impose, to update and to lift sanctions regimes. And as I mentioned earlier, the UK adopted its global human rights sanctions regime in July of this year, and that was the first piece of sanctions legislation adopted by the UK under SAMLA. So we've talked about how the UK implements the international sanctions. It then has domestic sanctions. SAMLA is a very key piece of legislation in that regard, and is going to become more important when Brexit occurs, and go on to that in a second. But as we've mentioned, the UK also then extends its national legislation, which includes legislation implementing the international regime, and it extends that legislation and those sanctions regimes to its overseas territories. And that's done by overseas territories' orders in council, so that that UK legislation then becomes law in those offshore overseas territories. It's important to note that sometimes the scope of those regimes may not precisely match the UK regulations in effect, and so it's always important to look at those slight differences because they do apply to different territories in different ways. So what then is going to be the impact of Brexit? And I would note at the outset, this is only going to be a concern for those territories within the Caribbean basin to which the UK extends its sanctions legislation. For those sovereign states that apply their own domestic legislation or have their own policy implementing UN and EU sanctions, it's not so much of an issue. But under the EU withdrawal agreement, which was signed in October 2019, EU sanctions will continue to apply in the UK during a transition period. And we're currently in that transition period, which ends at 11 p.m. on the 31st of December 2020. So UN sanctions will continue to be implemented through EU legislation by domestic legislation and EU legislation in the UK until the end of the transition period, 11 p.m. on the 31st of December. From the 31st of December, from 11 p.m., the UK will implement a range of UK sanctions regimes in the form of various sets of regulations which the UK will adopt under SAMLA. Now, they will replace, with substantially the same effect, the current body of EU law and UK supplementary legislation. So in practice, there should be very few gaps between the implementation and the content of the existing sanctions regimes in force in the UK, and by extension to some of us in the Caribbean, and what will be in place after the end of the transition period. Now, I would note that there will be some differences. The UK has organised its sanctions regulations in slightly different forms from those which are currently in place under the EU legislation. But to give you some comfort, those regulations are ready. They have been prepared and they are available to be downloaded and reviewed on the UK government's website, along with a lot of guidance. The Foreign and Commonwealth Office is also giving webinars on the impact of Brexit and sanctions following the end of the transition period. And so you can sign up for those kinds of updates on the Foreign and Commonwealth Office's website. So, some EU sanctions as well, because there's always an exception to every rule. Although the UK is going to be adopting all of these regulations, replacing the current regimes after the end of the transition period, there are some exceptions, and some EU sanctions regimes may not be addressed through those regulations, and they may actually be retained EU law under the EU Withdrawal Act 2018. Now, one practical point, because many of us screen sanctions lists which are published by the UK, it's important to know the UK has two sanctions lists. It has its own very large sanctions list, which has all sanctions, whether they're travel, trade, immigration, whatever it may be. And then we also have the OFSI list, which is a list of financial sanctions, which is prepared by the Office of Financial Sanctions Implementation of the UK government. Those lists will still be available for screening after Brexit. The key difference is that the OFSI list will get its feed from the UK sanctions list, because that's where those regimes would be enshrined, rather than from the UK sanctions list and also EU sanctions list, for example. So hopefully that gives you some comfort that operations should still be very much business as usual following the end of the transition period. So if we could just turn to the next slide, please, Melissa. We've looked then at the UK legislation. Now, of course, for those Caribbean countries which are not British overseas territories or have similar status, so perhaps there are some Caribbean nations which may have ties to EU member states historically. I'm not sure if there are or not anymore. But in those sovereign states, the domestic legislation implementing international sanctions measures is going to be the fundamental starting point for those regimes. Now, I do not profess to be an expert in sanctions anywhere other than the BVI and the Cayman Islands. So unfortunately, I can't give you an overview of those regimes. But I would note that even where a country is a British overseas territory, it may still have the power to impose sanctions domestically rather than simply relying on the UK. And apologies, but a good example of this is again the Cayman Islands, where we have implemented certain UN Security Council resolutions which relate to ISIL and Al-Qaeda and associated individuals. We've also implemented our own sanctions relating to the non-proliferation of weapons, the DPRK and Iran nuclear issues. The way that the Cayman Islands have done that is via adopting the terrorism law and the proliferation financing prohibition law, bit of a tongue teaser, and the Cayman Islands can impose their own financial sanctions under those pieces of domestic legislation. And again, that means asset freezing and restrictions on dealing with assets of persons who are sanctioned under that legislation. So, just to summarise, those are the four main sources of sanctions within the Caribbean. You have the UN Security Council, the EU Commission, the UK, and domestic legislation, whether domestic legislation is the fundamental source or whether it's supplementing all of the above. And if we could just go on to the next slide. But what about the US? Now, it's important to note, particularly in the BVI and Cayman, US sanctions are non-binding here. They are not law. However, due to geographic proximity and the nature of financial services offered by our jurisdictions, many of us have very strong relationships with clients, entities, and organizations which are established or resident in the US. And I know this is very important for those of you who are financial service providers which have correspondent banking relationships with banks based in the US. Now, where you have a US-facing client or relationship, you are going to have to bear the US sanctions in mind and screen against them. So what does that mean in practice? Well, the Office of Foreign Assets Control of the US Treasury Department, or OFAC, administers and enforces US sanctions based on, and I will come back to this later, US foreign policy and national security goals. The OFAC publishes lists of individuals and companies which are owned or controlled by or acting for and on behalf of targeted countries. It also lists individuals, groups, and entities such as terrorists and narcotics traffickers who are designated under programs that are not country specific. And such individuals and entities are referred to as specially designated nationals, or SDNs. And so the sanctions list that we screen if we're checking US sanctions is the SDN list published by OFAC. And where you get a hit in relation to an SDN, what that will mean in practice, and Sandra will go through this in more detail shortly, is that their assets are blocked, and generally speaking, US persons are prohibited from dealing with SDNs. Now, I've mentioned that the US sanctions are non-binding in many of our jurisdictions, and I have mentioned also that with the international sanctions regimes, the overarching aim is to maintain international peace and security. But with US sanctions, the purpose behind US sanctions is to promote US foreign policy and national security goals. And whilst there is a great deal of overlap between the UN Security Council sanctions measures and the sanctions measures adopted by the US, you need to keep that purpose in mind, because this can very much impact Caribbean nations in unanticipated ways. Trinidad and Tobago have been increasingly feeling pressure from the US to track and comply the US sanctions in relation to Venezuela. And for example, earlier in this year, in February 2020, Trinidad and Tobago cancelled an agreement with Venezuela for the joint development of a natural gas field which straddles their maritime border because of US sanctions on Venezuela's state energy giant, Petroleos de Venezuela. So the point I want to get across here is that the US sanctions are non-binding, but Often you will have to comply with them if you have a correspondent banking relationship, or you may be impacted because the purpose behind US sanctions is to promote and further US foreign policy and security goals. I am by no means any kind of expert in the ongoing discussions and relationship between Trinidad, Venezuela and the US, so I'm not going to say anything more on that. And on that note, we're going to move on to the second half of our talk, which will be Sandra. And Sandra is going to take you through how to navigate this sea of sanctions in practice.
Thank you. Thank you, Sara. And everyone, hello. It's so good to be out. And we unfortunately aren't able to do the conference in person, but thanks to the CRCA committee, we're able to at least bring you this presentation. Just to add to what Sara said, yes, none of us, I think, including anyone in Trinidad or Venezuela, are the experts on what's going on with the US. But anyway, what I wanted to do is to bring the practical side of this to you. Now that we have a good overlay of the sanctions regimes, and yes, it will vary from jurisdiction to jurisdiction, but the key is all of these stem ultimately from the UN, right? So the key thing to do, what happens to you as a compliance officer? First thing I want to point out is you need to know the risk tolerance of your company, right? Whether it is that your company is willing to accept this or not. So there are two things to take in mind. One is your legal risk, and that is exactly what is set out in the law and what you can and can't do. But more importantly is that reputational risk. So sometimes you can legally take on a client, but you may say the reputation far exceeds it. And I always like to say, as Warren Buffett says, you know, it takes 20 years to build a business and you can lose it in 5 minutes. Think about that and your reputation. It may change things a lot. So sometimes you come across entities where they're not taking it on. There's nothing legally wrong with it. And there's some people who have a higher risk tolerance than others. So it's always very important to know the difference between the two. Just as Sara mentioned, that's something you take into account with OFAC. First in the Caribbean, another big one is, for instance, we, especially with domestic legislation, we have nothing in place against Cuba, but there are sanctions that may apply to Cuba through the US. How do we deal with that? We may say just reputationally, it's just not worth the risk for our correspondent banking relationship to be cut down. Okay, so once you know the risk of your tolerance of your company, the next thing we need to look at is making sure you have a sanctions policy and procedure in place. And this is very important because one of the things that we in Cayman saw when we had our CFATF review, and I know some of you, the jurisdictions have gone through that review, some have not. Note in case you have not. One of the things we were seeing that there was this policy in place. And it's one thing to have it in your AML policies, but it must be specific. And I think that's where a lot of us get caught up. We are doing the screenings, but there's nothing specifically written down. So we need to make sure you have systems and controls in place to mitigate that risk, right? Stay up to date with the sanctions regimes in force. And that is easier said than done. And you know, one of the things we will do is you may look at what's coming out from the UN. When it comes down to you in your domestic legislation, it may vary slightly. And for instance, in Cayman, that's something we would say, especially when the Russian sanctions came into effect. The dates that it started to affect us in the region were different from the dates set out in the UN. And it's key to know that because sometimes you do have clients coming in knowing that sanctions do not legally apply in your jurisdiction and wanted to take advantage of that. And again, this goes back to the first point. What's your legal risk and your reputational risk tolerance there? Because legally you would be able to do it as the sanctions don't exist as of that date. Reputationally, you may say, well, we know it will come into force. Do we want to continue with that relationship or even start it? The other thing we need to do is you need to have taken into account the specific nature of your client's activities. And I'll give you an example of this. I had a client once in one of my many hats, not exposing any law firms here. And the client was in the EU and they provided packaging for long life products. The other end of this spectrum was who they were servicing, their customer was in a sanctioned jurisdiction and they produced dairy products. So when this transaction came across, of course, it made sense. And we understood what the client's activities were. But because that client was in that sanctioned, the customer was in that sanctioned jurisdiction, again, we had to decide whether legal or reputationally if we wanted to take that on. So it's really important to know because sometimes the activities may not be caught by the sanctions. And also the next thing we need to do is if you're relying on a search facility. So a lot of us use search facilities. We use, for instance, World Compliance. LexisNexis, TransWorld, World Check. We need to make sure if in that screening we are including sanctioned entities or persons. And this is key to know because these service providers provide you with lots of lists. And then on a practical side for us, if you're doing your screening on a regular basis, the list that comes out for you to check is a lot. And so sometimes people may say, we're spanning down what amount of lists we go against, but we need to make sure it does include screening for sanctions. And we also need to know how often is that list updated. So it's no sense to have a system running in the background that is only, we've set to only update once every 6 months, right? Or we need to determine how it is and where our client base is, what we need to factor in. The other thing is due diligence. So again, understand and know the transaction. In one instance, there was an instance where the entity was actually sanctioned, but the activity itself was not sanctioned because it predated, although activity was captured, it predated the sanctioned dates. So again, you need to understand and know and then make that decision. First, as compliance officers, what I would say is make sure that this is discussed with your senior management, because at the end of the day, this is a decision the company as a whole has to take. And I hope that takes some burden off of us as compliance officers bearing the brunt of all of these decisions. The other thing is you need to understand source of funds. And again, this was one of the things when we had our review, FATF, CFATF is looking keenly at. You need to know where those source of funds are coming from, because what if it is coming from sanctioned activity and flowing into pay your bill, right? So make sure that that is understood as well. And if I could just switch to the next slide. Great. So how is this done in practice? So let's look at screening. So as I mentioned earlier, you need to screen against applicable lists. So you need to make sure you know which lists those are. And of course, the list may vary from time to time. Who to screen is also important. So there are key things we know. Obviously, if you have a new client, you're going to screen, but also existing clients. So not because they've come through the door and they were fine then, sanctions can apply after. And it's the same thing I would say when Libya came into force. It was fine in December to do work with Libya, but then when January came, all of a sudden it was a no-no. So again, this constant screening should be taking place. You need to look at your beneficial owners, directors or equivalent, as Sara will point out to me. And the other thing is third-party payers. Who is it that one is paying and who is the payment going to? So those are very important things. And some of those things come across just in your practical side of things and accounting department, making sure you have that feedback both ways, because they may know sometimes if something changes on the payment end. In terms of systems and controls, we need to ensure the screening capture the sanctions list. As we mentioned earlier, the screening is done on a regular basis. And another key thing to note is do not assume the screening already done by a previous service provider has been done to what our expectations are. There may be a different risk profile, and they may, for instance, just deal with certain jurisdictions and not look at others. Or there may be a higher risk tolerance. So although there may have been a hit, they were fine to continue with the business. Again, reputationally, we may want to take a different approach. The other thing to note here is we need to understand the culture. So we need to look at naming conventions. And of course, this is always a mayhem when you're dealing with jurisdictions such as the Middle East, with how they name. You also have to look at countries like the Far East. And whether you have native speakers that are able to help you navigate through that is also something to take into account. And also who you're doing business with. And I just wanted to point out here, as Sara mentioned earlier, we're looking at dealing with OFAC, dealing with the US and the SDN list. There was one instance with who you're doing business with, make sure you know your client. Also, when remittances are coming into you through a correspondent banking relationship. There was one instance where the client was, let's call ABC Intermediate Limited, operating out of a country that was not on any sanctioned list. And they put in the payment note, as they were wiring the monies through the correspondent banking relationship into the jurisdiction, ABC Int Limited. It came up on the OFAC list as a hit. And so in that correspondent bank relationship, the bank in the US shut that down. We couldn't get payment regardless that it was an insignificant amount of money, because there was a hit on an ABC International Limited. So those are the things, let me tell you, it was a bane of my existence for around 3 months, but we did finally get paid. and filling out those forms is a nightmare for any of you who've done it. I know you sympathize with me. The other thing to do is to make sure who you're collecting information on the individuals and the entities. And one of the things is we know you need to get place of residence and country of origin. But the other thing to look at is the location of the business and the country in which the business is conducted. So a lot of us that do offshore finance, you want to make sure that the entity may be established in Cayman, in the BVI, in Curacao, but where is it the actual work is being undertaken, right? So it could be in Syria, but we need to make sure we know where it is and if we want to venture down there. And I've just put up here some additional considerations to take into account. Where the AML function is outsourced, and we're seeing that more and more happening, we need to ensure it covers sanctions. So for some of us who do an audit, we do go in and ask, can we see the list of the list that you screen against? Because some AML consultants may not include sanctions in their coverage, right? It may strictly be on the AML side of things. And if they do, are they relevant to the jurisdiction? One of the things we see, for instance, is where things are outsourced in the US. So there are screening sanctions, but it's against OFAC list. It's not including some of the things. And although these all stem from the UN, they're not including the local legislation as well that will apply to us. So that's very important to make sure in the back of your mind, whether you have your checklist to go through all these things when you're taking in a new client, to ensure all of these things have been met. And if I could then just move to the next slide. Great. So we've done all of that, and we've now come up with our targeted financial sanctions hit. So what do we do? So the first thing we need to do is maintain a record of any possible matches, or as we call them, hits in our world. And I have to be very careful when I go around using the word hits, and I got a hit, to name on sanctions lists and related actions, whether the match turns out to be a true match or false positive. So you need to make sure you document that, why it is a false positive, that's the case. And Sara, I know this is one of those that are keen for you.
Yeah, if it is written down, it doesn't exist. That's what our regulator tells us when they're doing audits of your sanctions policies and procedures. So remember, and they said it to us so many times, document, document, document.
That's right. So the fact that you may say, oh, our risk tolerance is 0, we're not doing sanctions, we still need to make sure we have a policy that says we do not do sanctions and we have all our mitigating factors set out. Such records of sanction hits must contain as a minimum, so we have them set out there on the slide, the basis or other grounds which trigger the match. So you can say this was your weekly screening. Hopefully it's not your annual screening, you know. Any further checks or inquiries undertaken. So again, like in my case where I had that hit with the entity, we knew that it was not correct, but I could set out what I did to ensure that this was not from the same jurisdiction, that this was, you know, client that was screened accurately. We also need to look at the person involved, including any members of compliance or senior management who authorize the treatment of the match as a false positive. So again, this is where you have your records. And if you maintain that spreadsheet, you have your authorization, it has been reviewed. So if you have someone junior going through the screening, it has been reviewed and found to be sufficient. That must be also documented. And the other thing is the nature of the relationship with the person or the entity involved, including attempted or refused transactions. So even if it is that you've turned down the transaction, make sure it is documented. All of these things help to build that picture when it is the authorities coming and may ask questions. And the other thing we need to look at is and document is if any subsequent action has been taken. So for instance, as Sara mentioned earlier, if it is that you are freezing the funds, which is something allowable under some legislations as well. And if I can just move on to the next slide. So, okay, what do? We've done that, we've done our documentation. Do we cease dealing? Do we stop dealing with the entity that may have been a client for a long-standing period of time? So if you're not sure, what we need to do is review the information you have and consider requesting further information. Because again, it could be that the particular activity is not captured. The person may be captured, but not the activity. And on the flip side, it may be the activity that's caught, not the person. And it's important for us because in financial services, we could be caught up in assisting an arrangement, which is one of the offenses in most sanctions regimes. So we have to make sure we don't fall afoul of that. Otherwise, we may immediately freeze any accounts, and most legislation have that in place. I know one of the things with us, for instance, Bermuda has a much more advanced sanctions regime than Cayman, is the fact that the ability for them to put into place as soon as a sanction come out that it affects the region. For us in Cayman and BVI, for instance, a sanction may come out and we have to then have it extend to us, or it used to be overseas territories order and then gazetted in your local legislation. And that could take some time, and that's been criticized on, making sure that within 24 hours you can actually put sanctions into place so that if it's necessary, you can freeze funds where it may be relevant. You may want to refrain dealing with the designated person. And the other thing is to not make funds or assets available to designated persons or entities. So if you want to then continue with the business, you can actually apply for a license to deal with that sanctioned person or entity. Another thing to take into account is you may want to file a suspicious activity report. And one of the other things I would recommend strongly is you may want to take independent legal advice, because I know as compliance officers, we're the ones actually reading the sanctions. So a lot of people come to us looking for us how to take things forward. We can give our view, but sometimes we want to say, let us get that independent legal advice as a sense check for what we're doing, because sometimes we do have conflicts between us and the business in going ahead with the business. So that is always something that is readily available as well. And if I can just move on with the next slide, would be great. So again, there are exemptions, which is the licensing. And the key thing to know is we need to look at the licensing regime. And I mentioned earlier, you may want to file a suspicious activity report. Your licensing regime may be different under here. So it may not necessarily be to the same authorities you filed your suspicious activity report to. And you need to also determine what if the assets of a non-designated person are frozen. So it was a false positive, but the assets have been frozen. And as I said, there is a process to go through, as I've had to do on a few occasions, to make sure we can justify and show proof that this client was not the designated person. The other thing is to report. So you need to report as soon as practicable. And I always love the legislation. It doesn't tell you within 30 days or 6 months, as soon as practicable. If there's knowledge or reasonable cause to suspect that a person is a designated person or has committed an offense under the applicable legislation. So you need to report it. As I said, you need to make sure we know who we're reporting it to. There may be a different form from your suspicious activity report form that you may want to take into account. You need to disclose. So make sure when you're filling out that form and reporting, the amount of information you have on there is the information or other matters on which the suspicion was based. Any information you may have about the individual or designated person by which the customer can be identified. So again, you may have to go into quite a bit of detail there on what you have. Details of any frozen funds. So if you have had to take the action to freeze funds or assets or other actions taken in compliance with the prohibition requirements. And also, again, remember attempted transactions. So even if you have turned it down, we need to make sure we report that. And I've stressed it here again, use the designated reporting forms where applicable. And additionally, the AML CFT reporting requirements. So you may have a different form to fill out because you've come across a designated person or prohibited transaction. But you also need to remember that there may be AML breaches arising as well. There may be money laundering involved. It could be counter-terrorist financing. So you may have to file 2 separate reports. So it's very important to always keep that in the back of your mind if there's suspicion of that and the different regimes. If I can move on to the next slide. So some of my final thoughts. So one of them is internal audit. So some things that I've come across that I think we need to take into account. We need to make sure that internal audit looks at sanctions. So one of the things we've been seeing as sort of a pitfall is no reviews of financial sanctions procedures during internal audit. We're so focused on AML that we've totally slipped on sanctions. Some exemptions, so this is some of the things we've seen feedback from industry. They figure there's an exemption because they're only processing low value transactions. And of course, that's one of the biggest misperceptions that we need to make sure isn't done. Just look at 9/11. It didn't take a lot of money to do what happened there. So not because it's low value means you're exempted from the regime. And another one that I've heard is there's no need to screen if you don't hold client money. Again, that doesn't matter. The regime is, as Sara mentioned earlier, what we're trying to achieve in terms of that jurisdiction we're trying to bring in line. And timing, that is another one that is very important that we check. The screening done days or weeks after the take on of business rather at the beginning. So we may have certain things in place to do our automatic screening, maybe a certain date of the week, of the month, but we also need to be doing that screening initially as the client is coming in. So before they even get through the door, we need to look and make that risk assessment, whether we want to take that client on or not. And then another one we've been hearing, and hopefully none of us will have that after this, right, is training. That the training does not incorporate sanctions. That has been a big one. And for us here in Cayman, the regulator has been stating we want to see specific policies in your manual covering sanctions. We want to see that training has been done covering this. And so it's always important to do that. And for jurisdictions going forward that haven't done this, please bear in mind, especially as compliance officers, to incorporate. Then if we can move on to the next slide. In wrapping up, I just wanted you to remember these things as well. And it's wearing a sanctions hat as opposed to an AML hat. One is politically exposed persons are not necessarily sanctions targets. So not because it's a PEP means that we have to go and assume that they're also sanctioned. There may be instances where they are, like we know when that Ukraine sanctions came out. And also tipping off does not generally apply to sanctions. And so in that instance, when I was telling you about the client that had the long life products and the dairy company, the reason we found this all fell in the sanctions regime is that they had to apply for a license. So they were very forthcoming with what was happening there. And again, that was not tipping off. So please bear that in mind. We do get very cautious, especially with tipping off provisions. We're very careful in making sure we don't breach that for us in the industry, because those are offenses that will apply to us in person. And with that, I think I've reached to the end of my side of the presentation, and I hope we've all found it very helpful and useful in navigating through the sea that we're in, especially this time with Hurricane Ah Comin. We certainly are. We've had to have a few lockdowns in the office due to hurricanes. Obviously, as you can tell, we're fine for COVID reasons. We can meet, which is really great. So we're not reaching those restrictions here, Sara and I.
Yeah, we're very lucky in Cayman.
Well, thank you. We're getting a lot of questions, and also if you're okay with us switching to the Q&A, or do you have something else you'd like to add at this point?
Nope.
Thank you so much. Speaking on screening, Sandra, I got a few questions on what would you consider as a best practice as far as what you're referring to as a regular basis, screening on a regular basis.
So I think what we should do, and as a compliance professional, we do have to weigh it up. I think what you need to do is ensure you're screening as the client comes in. And on a regular basis will depend on the volume of your business. And so whether that will be a weekly basis or a bi-weekly basis or a monthly. And what I have seen in my experience with regulators in various jurisdictions, they really don't set a limit, but they want to see that it's on more than, let's say, once every 6 months or one every year. So I think if you're doing it up to probably monthly, it might be fine. But again, you have to look at, the volume of business coming in to determine, because if it is that the volume coming in is low, you may be a bit safer going once every week or once every 2 weeks, or adjust accordingly.
Could you also go a bit deeper, Sandra, on what would be considered tipping off within what you've presented, and specifically if you freeze an account regarding positive TFS, could that be tipping off?
So this is where we do have to get a little careful, because we have to look at what elements are involved in that, and if there are indeed money laundering concerns, because then you will tip over the tipping off to AML. And I know a lot of people get very concerned. One of the things I have to say with the regime, and each jurisdiction is different. There's some jurisdictions that even for AML, you get feedback from the reporting authority, that you filed with what to do going forward. Some instances you don't, but I think once you get into sanctions, you do get that feedback coming in. One of the things I've also been seeing is the financial regulator, which may not necessarily have oversight for sanctions, may also send out generally, trying to get a feel when a new sanction comes in place, what the jurisdiction has to know what the level of exposure is. So again, it has to be careful on a case-by-case basis whether to freeze or not. But in some instances, because it's publicly available information, it is on a designated list, it is published by the UN, that may not constitute tipping off unless, as I said, you have indeed money laundering underlying offences created as well.
You do have to bear in mind that as a financial service provider, you are probably under a legal obligation to freeze, which will give you, some element of comfort. So you need to look at your situation, consider the legislation and what actions you could take, reach out to the reporting authority, the FIU, if you can, but also document your concerns. Document.
And in some instances, just to add to that, the legislation may set out how long those funds can actually be frozen for. And it might be just enough time to allow the authorities to come back and give you guidance on how to proceed.
Before I get into the rest of the questions, I've gotten several people that have written asking if the session's being recorded that they'd like to share with the rest of their compliance team. And so just to let everyone know, yes, the session is being recorded and a video will be sent to you automatically tomorrow. It takes a while to render, so you'll get a copy of that tomorrow, a copy of the video from today's session. Now, getting back to the specific questions, could you explain a bit more about the licensing regime? How does it work in the jurisdictions that you're familiar with?
Do you want to take that one? Yeah. Yes, so it's where you want to continue business with an entity that usually would be undertaking activities into sanctioned jurisdictions or would be undertaking activities which would themselves be sanctioned. So transport of arms, transport of components that could be used in chemical weapons. A lot of those businesses will be legitimate, excuse me, and those clients themselves may well have licenses under the regimes that are applicable to them. If we know all of this, and as Sandra says, if that's a legitimate business, they will be very upfront and forthcoming when they are trying to engage you. You can then make your risk assessment, figure out if this business is good for you, and then in the Cayman Islands, it's actually the governor's office, I think, who is in control of financial sanctions, and you would make an application for a license there. There are various levels of red tape to sometimes go through. So, for example, depending on the activity, the governor may want to talk to the UK. If you were applying for a license under a UK regime, the UK may actually have to refer that to the international body, the Security Council. So there can be timing implications where you're applying for a license. And also because if you're dealing in our jurisdiction, because we're offshore, you may often find that the underlying clients themselves have licenses to conduct the activities that they're doing. Just in terms of the UK and Brexit, I understand that licenses that have been issued by the UK government, the extant licenses, the ones that are currently issued, will be fine up until their usual expiry date. But it is worthwhile checking if you are relying on licenses of your clients to then allow you to apply for a license in your jurisdiction. Check those expiry dates because there will be some small differences after Brexit takes effect after the end of this year.
Sure. And just to add to that, you may want to apply for a license where you have a sanctioned entity, but it's for your payment for your services, and that is also allowable under the regime.
Fantastic, ladies. I don't have any other questions in line. So we're going to go ahead and end the webinar right now. I'd like to thank you very much for joining us, ladies, and to the entire audience. You've been great. You asked a lot of questions. We're very attentive, and we really, really appreciate your participation in today's session. So stay tuned for more from CRCA. Tomorrow you can look out for the video. A few people have asked for a copy of the presentation. You can email me and we'll coordinate with the ladies on that. So thank you very much, everyone, and have a wonderful day.
Thank you. Thank you again, everyone.